Swayam Prabha. Digital India. Educated India.
I extend my very warm greetings to all of you, dear students. I am Dr. Raju Maji, Assistant Professor, Faculty of Law, Banaras Hindu University. Now, in the last lecture, we have discussed about the various kinds of negotiable instruments. Just for your reminder, or just I would like to recall certain things before discussing that who are the parties of the negotiable instruments and what are their rights and duties. We will discuss in this lecture number 13 about the various kind of, you can say, the parties of the negotiable instruments, and at the same time we will discuss their rights, and mostly this lecture is very much concerned about the establish what are the liabilities of this. Now, just to see that when study we have discussed, so naturally that when the parties are entering into in the any way, they are liable to each other, particularly negotiable instruments. When we are talking about, it is the means, the modes of payment, and in the direction we have already learned about that, the promissory note, the bill of exchange and the check. As we have seen that the promissory note is an undertaking, and where we have seen that the two parties are there, that is the maker and the pay. On the other hand, when we have discussed the negotiable instruments as focused on the second and the third, that is which is defined under section 5 and section 6. Section 5 talks about the bill of exchange and section 6 talks about the check. As I have told you, the bill of exchange is the pre-existing relationship. The bill of exchange, when we are talking about, it can be made between these two parties, but exactly if you will find, then there are three parties. These three parties are defined under section 7 of the Act, under the Negotiable Instruments Act itself. These are the drawer, drawee and pay. As focus on the bill of exchange, we have already seen that the parties is persons who is making the bill of exchange, he is called the drawer, and it is not an undertaking, it is an order. He is making an order to the drawee. Who is drawee? Of course, there is, I have already mentioned, again I am reiterating it, that there is a relationship between the drawer and drawee as a creditor and debtor. As a creditor, he can make an order towards its drawee, and the drawee is the persons who is to obey, or you can say to follow the order which has been made. And what is the order under the negotiable instruments? We understand that the order can be made for the sum only or for the money only. So, naturally he might have written an instrument in form of the bill of exchange, and he has made an order towards his drawee to make payment the persons who is bearing that instrument. Who is that person? That is the payee. In the same way, the check, when we are talking about, the check is also a bill of exchange, and the bill of exchange means here that there is also the drawer and drawee. The distinction between these two, the check and the bill of exchange, here the drawer, he must be a customer of a particular bank, and the drawee, he must be a specified bank. So, in between there is a relationship, again it is existing relationship, or relationship is already established there, the creditor and debtor. Customer is a creditor, he can make an order to his drawee, and the persons to whom going to be paid, means the persons who is presenting the check, he is a payee. So, sometimes we find that the if you are, means the same person, that is the drawer and payee is the same person if the persons is making the instrument itself and he is presenting the check before the bank itself. So, he is playing a double role, we can say, as a drawer when he is drawing the check or preparing the check, and when he is presenting before the bank, he has become a payee. Now, with this background, just I would like to mention here that one very important section as far as concerned, which is talking about that there is a relationship between, and that relationship establish some sort of, you can say, the responsibility. The relationship between party on a negotiable instruments and the holder is either of a principal debtor or that of surety. Now, as you have discussed the endorsement, under the endorsement study we have seen as one question the negotiability completed. That means the persons went by putting his signature, his transferring the documents, instruments to the other person who is become the endorsee. Endorsee, as soon as he received that, when he got that instruments from the previous holder, or we can say that from the endorser, he will get as an endorsee, that is the entitlement. What kind of the entitlement? He has become a ownership of that instrument, and being a owner of that document has a right to again to negotiate. Means this being a holder, he has every kind of the right as far as concerned for the further negotiation. So, the section 37 of the Negotiable Instruments Act 1881 states that the maker of the promissory note or check, the drawer of a bill of exchange until acceptance, and the acceptor are, in the absence of a contract the contrary, respectively liable thereon as principal debtor, and the other party thereto are liable thereon as sureties for the maker, drawer, acceptor, as the case may be. Let me explain this particular section. As I have told you that the liability arises as soon as the party entered into that kind of the contract. Now, when either in form of the order or in form of, you can say, the undertaking. When we are talking about the undertaking, we are talking about the promissory note. When we are talking about the order, we are talking about negotiable instruments or check, whoever may be. The responsibility lies as soon as the parties are entering. How the parties are, means the negotiability is doing on, it is going from one hand to another, and as I have told you, unless the payment is made, that process will continue. So, within that process we will find that so many persons are involved. So, that the liability is the maker, that he has to complete that assignment. How it will complete? When the payment is done. So, during that period, if suppose that instruments is dishonored, in the circumstances, each and every person, those who are, you can say, under the process, all are, they are playing as a role as a surety of that. So, as I have told you that this section is talking about, in case of the bill of exchange, acceptance is required. The reason behind it, because it is not like the bank, because the bank, whenever the customers will demand, it is the duty of the banker to make payment. But as far as concerned that when we are talking about the same kind of relationship, that is a creditor-debtor relationship which existed when the parties are entering into under the bill of exchange, it is not like this. You cannot demand like this, because there is might be some sort of, you can say, the time and everything which it is available in the contents of the negotiable instruments, that is under the bill of exchange. So, in that cases you cannot do that. So, what is required? The acceptance is required. Unless the drawer is taking an acceptance from the drawee, that cannot be compelled. So, in that circumstances, in case of the bill of exchange, it is very important that the acceptance must be taken, or you can say obtained from the drawee. Now, I would like to cite one case, that is Dalsukh versus Motilal. It was decided by Nagpur, and it was held that in the case of a bill of exchange, the drawer is the principal debtor unless it is accepted, but after acceptance, the drawer's liability is changed to that of surety, and the acceptor becomes the principal debtor. Now, let me see how the status is changing. As I have told you that where as a holder, your rights, you are not liable for it. Who is liable? From where the previous. So, but when you are assigning to others, then you are also not a principal debtor, but you are acting as a surety. So, under this case, it was very clearly mentioned as far as concerned that in case of the bill of exchange, it is not required under the check. But as far as the bill of exchange, the court very beautifully observed that in the case of Dalsukh versus Motilal, it was held that in the case of a bill of exchange, the drawer is the principal debtor. The drawer is the principal debtor. He will continue that. When that status will change, until it is accepted, but after acceptance, the drawer's liability is changed to the of the surety, and the acceptor becomes the principal debtor. The debtor will change immediately. How? As soon as he has given its acceptance, now the drawer will become the principal debtor, and the earlier the maker, you can say, the drawer, he was as a principal debtor, but as far as concerned the acceptance he received from the drawee, his status will change, and now he has become the surety. Now, let us have a look on the various kind of parties which are involved in the negotiable instruments. So, the parties are the negotiable instruments which the certain things which I have discussed earlier also. Just I like to recall all the things. The parties of the negotiable instruments. The negotiable instruments is prepared by, it starts from that, and when he is preparing all the conditions which he required, that has to be fulfilled. So, the maker is the first, you can say, the parties of the negotiable instruments. The maker, a person who makes a promissory note, that is, who signs an instrument which contains an unconditional undertaking by him to pay a certain sum of money, is known as the maker of a promissory note. As I have told you that the maker word we are using with only the promissory note, where the two parties are there, one who is making the instruments, means he is one sort of, you can say, the undertaking, and he is entering into it, that he is promising to pay it. So, he has become the maker who is preparing the promissory note, and the promissory note, what he is doing, that he is making a statement. And what is that statement? I promise to pay, I indebted to you, and that must be with a unconditional undertaking. And yesterday I have discussed about that in the previous lecture. I have discussed that what do you mean by that, and that unconditional, as I have told you, the unconditional, it does not mean that date and other conditions cannot be put. The conditions, such kind of the conditions can become under the definition of unconditional, which conditions cannot be performed very easily, or there is, you can say, the uncertainty there. The conditions which is full of uncertainty, that will not be a part of it. As soon as you are putting such kind of conditions, that will become the conditional one, and it is the talking about the unconditional undertakings must be there. So, the unconditional, we can say that anything which can be performed, or which anything which naturally will take place, that will not consider as a condition, and the remaining things which are such kind of, you can say, the circumstances if you are creating, and that cannot be performed normally, or it is very uncertainty, full of uncertainty is there. So, that will become a conditional one, and it is not permissible under this. The drawer, as far as concerned, as I have told you, the drawer term has been defined under section 7 of the Act, and the maker of the bill of exchange or a check is called the drawer. As far as concerned, the persons who is making a check or the persons who is preparing a bill of exchange, that persons is termed, or you can say we are calling him that he is a drawer of that instrument. Again I am repeating it, section 7 which defines that who the persons who is a drawer, it says the maker of a bill of exchange or check is called the drawer. The persons through whom the bill of exchange or check is prepared, he is comes under the definition of, according to section 7, he is a drawer. Then the next party which is involved under the negotiable instruments, that is drawee. That is also defined under section 7 of the Act itself, and it says in the case of a bill of exchange or a check, the persons who has been directed to pay the amount is known as the drawee. In the case of a check, the drawee is always a bank. So, as I have told you that the why both are comes under the definition bill of exchange as well as the check, both are comes under the definition of means it is defined in the two sections separately, but as far as concerned, when check is defined, it is also defined, the check is also a bill of exchange. So, the difference between these two, that in case of the bill of exchange, any persons can be entered, where between the two persons that the relationship is already established relations between the two persons, that is the drawer and drawee, means the creditor and debtor. In the same circumstances, in the check also there are existing relationship or the relationship which has already been established, that is the creditor debtor relationship, and that is between the customers and a banker. So, in case of the check, the drawee is always a specified banker. Now, the another terms which has been defined under section 7 of the Act itself, under the Negotiable Instruments Act, it is talking about the drawee in case of need. Now, the drawee in case of need is a person when in the bill or in any endorsement thereon, the name of any person is given in addition to the drawee to be restored to in case of need. Such persons is called the drawee in case of need. So, that the persons apart from the it is talking about that, try to understand that who can be called the drawee in case of need. A persons when the bill or in any endorsement thereon, the name of any persons is given in addition to the drawee to be restored in the case of need, such persons is called a drawee in case of need. Such persons is called a drawee in case of need. As I have already discussed with you, that is the another parties of the negotiable instruments, that is acceptor. Who is the acceptor? The persons who is giving acceptance. So, it is after the drawee of a bill has signed his assent upon the bill, or if there are more parts thereof than one, upon one of such parts and deliver the same, or give a notice of such signing to the holder or to same persons on his behalf, he is called the acceptor. Acceptor is the persons, as I have told you, it is involved as a drawee in case of the bill of exchange. As I have told you, the drawee cannot be held liable, because in the we have already discussed that who is the principal debtor in case of the bill of exchange. The initially the persons who is preparing it, means the drawer is the principal debtor, and the principal debtor status can be changed only when it will be changed when the drawee is given acceptance over that instruments. As soon as the drawee is giving acceptance, the drawer status will change. Now, the drawer become a suretor. He is not his status is changed from the principal debtor to the surety. But as far as concerned that the acceptor, the person who is giving acceptance, and acceptance, after giving acceptance, he may put his signature, and he is giving consent by putting his signature on that instruments, and he has become now, the drawee become the principal debtor as far as concerned the persons to whom he is going to make payment, that is for the purpose of pay. Acceptors for honor. The acceptor for honor, it is a persons when a bill of exchange has been noted or protested for non-acceptance or better security, and any person accepts in supra protest for honor of the drawer of any one of the endorser, such persons is called the acceptor for honor. Again I am repeating it, who is the persons when we are talking about when a bill of exchange has been noted or protested for non-acceptance or for better security, and any persons accept it supra protest for honor of the drawer of any one of the endorser, such persons is called an acceptor for honor. Now, during the process of endorsement, the many persons are involved as an endorser and endorsee, and it has undergone through the various hands. So, in the circumstances might be there some persons, as we have discussed the kinds of endorsement, then we find that there may be some the restrictive, there may be someone it can be do with the conditional. So, in the circumstances the some might have giving some sort of the surety, and he is giving surety if in case of when whether it is non-acceptance or you can say it is dishonour. In both the circumstances, the persons who is taking liability with the help of you can say the endorsement. So, that kind of persons is termed as an acceptor for owner. The pay is a very important as far as concerned the part of the negotiable instrument, and the pay, the persons named in the instrument to who or to whose order the money is by the instrument directed to be paid is called the pay. As I have told you that in all the circumstances, either in the bill of exchange or check, we will find that to whom the payment is to be paid, that persons is called a pay. Now, the endorser and endorsee is related with endorsement, as we know that the endorsement, how it can be done. There are the various process, the endorsement, but the process is very general. The process is very simple. If you recall what we have discussed earlier under the chapter of the endorsement, at that time find that to complete the endorsement process, these two persons are required. What is required? The first thing is required that the person is putting his signature. That means he entered itself, or he indulged himself or herself for what? To making the instruments by putting his signature. As soon as besides, or you can say the apart from the maker, the any person who is putting his signature on the back of the instrument, he is called the endorser. And after putting that signature, when he is giving, or you can say the negotiating, or he is transferring, or he is delivering to someone, as soon as that the delivery is completed, the persons to whom the instrument has been delivered, he is a endorsee. So, these two terms have been defined under section 15 and section 16. Section 15 is talking about, we define the endorser. It says, when the maker or holder of a negotiable instrument signs the same, otherwise then as a such maker, for the purpose of negotiation, on the back or face thereof, or on a slip of paper annexed thereto, also signs for the same purpose a stamp paper intended to completed such a negotiable instrument, he is said to be endorser the same, and is called the endorser. And in the other hand, when we are talking about, which is defined under section 16, and it says who the persons the endorsee. It says the endorsee is a person whose favor the endorsement is made, that is, the person in whose favor the negotiable instruments has been transferred by an endorsement. So, as I have told you that these two persons are involved in the completing the process of endorsement. The one person who is endorsing it, he is endorser, and the another persons after endorsement to whom it is delivered, he is endorsee. Now, the two very important definitions which is again defined under the section 8 and section 9 of the negotiable instruments. The one is holder. The holder plays a very significant role. As far as the literally meaning, if you will see what to mean by the holder means the person who is holding. And on the other hand, when we are talking about the holder in due course, that means the person is holding for a certain moment or for a certain time. He is not, you can say, the entitled, but he is entitled for the certain regions, or you can say the certain situations, conditions, circumstances which is prevailing, and at that time we are calling that holder in due course. So, let us, section 8 talks about that who is a holder. It says the holder of a promissory note, bill of exchange or check means any persons entitled in his own name to the possession thereof, and to receive or recover the amount due thereon from the party thereto. Now, so it's a very important definitions which he made as a holder. Holder means the person who is possessing that instrument, and when it is under his possession, he is entitled to get payment from the persons who is responsible to pay it. Again, I am repeating it. If you read this section, it will the rights appears of that persons. What is that right? To receive or recover the amount due thereon from the parties. He is entitled to get the payment. That is very important. As a holder, when you are possessing, how you have possessed it, if you are entitled to get that, so you becomes a holder, and as a holder it says the holder of a promissory note, bill of exchange or check means any persons entitled in his own name. That is very important. That only we can think about that. He is a holder. What is that? The persons entitled in his own name to the possession thereof and to receive or recover the amount due their own from the parties. That means there is no any kind of, you can say, the any things in contrary to that rights is prevailing there. As soon as if any kind of the, you can say, the in contrary to that any kind of contract they have been entered, then he is going to seize their rights and he cannot exercise. As a holder, that you have not entered any kind of in contrary to your rights, and as a rights, when you are holding that, you are holding as a proprietor of it, and as a proprietor you can have that right to dispose of it. So, you can further negotiate, or if you have a right to recover or to receive the payment from the parties who are liable or who are responsible for it. So, the very important things which I am going to share with you, that is holder in due course. Now, normally if you see the holder in due course means any persons for consideration become the possessor of a promissory note, bill of exchange or check if payable to bearer, or the pay or endorse thereof if payable to order before the amount mentioned in it became payable, and without having sufficient cause to believe that any defect existed in the title of the persons from who he derived his title. Again I am repeating it. It is defined under section 9 holder in due course, and it says the holder in due course means any person for consideration become the possessor of a promissory note, the bill of exchange or check if payable to bearer, or the pay or endorse thereof if payable to order before the amount mentioned in it become payable, and without having sufficient cause to believe that any defect existed in the title of the persons from who he derived his title. Now, the previous holder, if there is any kind of the defective, so for that purpose he is not responsible for it. Now, just I would like to cite one example which you can understand that when we can say the holder in due course. The word specifically mentioned that the holder in due course. The very good example you will find, and I think that is only one of the appropriate example which through which we can understand that who is a holder in due course. Now, come to the things which I have already discussed, the functions of the collecting banker. Now, the collecting banker, he is acting as an agent, because you have given assignment, and to what the customer is asked his banker to collect a check, because the check is issued in a cross form. So, cross form means it will be deposited in the customer's account. Now, when it is deposited in the customer's account, as an agent, what the bankers will do? Bankers will send it and he will collect the money. When he collected the money, he will enter it in the customer's account, and after making, or you can say completing all kind of procedure, as soon as his amount which has been collected by the banker, it is credited in the customer's account, then only the customer is entitled to withdraw that money. Before that, he is not entitled to withdraw money. But as far as concerned that sometimes the banker is doing some sort of, you can say, favor towards the customers, and when the banker is doing some sort of favor, we can say in a good faith, that without collecting money or without receive money from the check, he is going, or he is allowing the customers to withdraw that money. So, what happened that when he is allowing to withdraw without collecting money from the concerned bank, that as soon as the money will receive, he will credit it in the customer's account. During that period, the banker is acting as a holder in due course, because the money, he will hold that money. He has the right that money, because he has already paid that money. So, the holder is playing as a holder in due course. Now, come to the next very important things which I like to share with you, that is capacities of the parties. Now, as you know that there are because the contract is very important, it plays a very significant role, and you might have read under the Contract Act, the sections 11 plays a very significant role, which is talking about the capacity, the persons who is entitled, or you can say who can enter into a contract. So, the capacity of parties, when we are talking about, every negotiable instrument is essentially a contract. It is therefore essential that the parties, namely the maker, drawer, drawee and payee, should have the capacity to enter into a valid contract. Now, when we are talking about the negotiable instruments and the parties, those who are concerned, which we have already discussed, all the parties must have means they are must competent to enter into a valid contract, or we can say they are competent to make a valid contract. Unless and until they are have a capacity to enter into a valid contract, they cannot discharge their liability. That is why according to section 11 of the Contract Act 1872, it says, it describes, you can say, that when we can say the person is competent or the person is all right, he can enter into a contract. So, it says a person who is of age of majority. The first essential the elements as far as concerned or towards the party must be the major one. The majority as far as concerned is defined that the parties have already, or the parties are already completed the age of 18 years. But if he is living under the guardianship through a court or by any authority, in that circumstances the party must have completed the age of 21 years. So, the majority word is there, of sound mind and not disqualified from entering into a contract by any act, is competent to enter into a valid contract. Now, that is the sound mind and not disqualified from entering into a contract by any act, like a person who has already declared insolvent. So, he is barred by the other laws. So, that is also important, that if by the persons is not disqualified. So, the three things we are getting as my question, that the persons is competent to enter into a valid contract, that the first thing is he must be a major one, and the second thing it is talking about that he must have a sound mind, status of the sound mind, and the third one is talking about that the persons is not disqualified by any other law as far as concerned, the persons is competent to enter into a valid contract. Now, capacity to make etc. Promise note like it's very important provisions which you will have to see under the Negotiable Instruments Act 1881. Section 26 of the Negotiable Instruments Act 1881 provides that every person is capable of contracting, that means the persons they are competent to enter into a contract as the qualifications has been prescribed under section 11 of the Contract Act of 1872. So, the every person is capable of contracting according to which he is subject, may bind himself, and he bound by the making, drawing, acceptance, endorsements, delivery and negotiation of a promise note, bill of exchange or check. As soon as that he is competent one, he are undergone through all the process which are negotiable instruments will undergone through all the process. These process are, that is the acceptance in case of the endorsement, the delivery, the negotiation of a promise note, bill of exchange and the check. Now, if a party to negotiable instruments is legally incompetent to do any of these acts, the contract is void as against him. However, the incapacity of one or more of the parties not affect the liability of other parties. So, like if we take the example of if the firm, there are many means the partners are there. So, if the any persons has been declared the incompetent by any law, then it does not mean that the others are also not they are not competent, they are competent. So, now the very important things which I like to share with you, that is liability of the parties. Before we discussion about the liability of the parties, let me tell you that the rights of the parties. As my concern, when we are talking of the rights of the parties means he is entitled to get, and suppose it is not redress through the general process. So, party has the right to sue any of the persons, those who are responsible for it, and that the payment must be done as far as concerned the negotiable instruments. Negotiable instruments, as I am talking about, as we have seen, that any kind of either the undertaking or the order that is made for what? For the sum only, for the money. So, money is there, and money means that the persons who is responsible, the pay must be payment must be made to the pay. So, the liabilities of the parties, the Negotiable Instruments Act 1881 casts certain obligations and liabilities to various parties to a negotiable instruments that can be discussed in the following heads. Now, liability of a drawer of a bill or check. The bill means the bill of exchange. So, what are the liabilities of a drawer? The drawer is the persons who is making an order, and he will not make the payment, but he is responsible. Why? Because he is giving the surety. We have already seen that his position is initially when he is making that he is what we can say that he is the principal debtor at the time, and as soon as it is handed over or acceptance is taken, then he is not a principal debtor. His status is what? His status is surety. So, the section 30 of the Act provides that the drawer of a bill of exchange or check is bound in case of dishonor by the drawee or acceptor thereof to compensate the holder, provided due notice of dishonor has given to or received by drawer. One thing which is as a payee, the responsibility lies. What is that? That you will have to inform. Now, who is the drawee, a person, for example, in the bill of exchange also, or for example, a check. I am taking the check, as we know that the customers are there, and the customers issued a check to someone who is payee presented it, and the payment is not made. The payee has no right to ask the banker, means the drawee, because the drawee, there is no relations between the payee and the drawee. The relationship is between the drawer and payee, and the drawer relationship is with the drawee. So, the drawer is entitled to sue against if anything happened, or you can say any kind of, you can say that demand can be made from the drawer, from the drawee, and but as far as concerned when we are talking about the other hand, that the payee is directly linked with the drawer, and but how he will get that? He has to inform about the dishonor, who is the drawee bank has not made payment, or you can say the acceptor has not made payment. In both the circumstances, in case of the bill of exchange and the check, the persons can be held liable, and it says the section 30 very specifically mentioned, provides that the drawer of a bill of exchange or check is bound in case of dishonor by the drawee or acceptor thereof to compensate the holder, provided due notice of dishonor has been given to or received by drawer. So, as far as concerned the payee, his liability is that he has to issue you can say or inform notice by any means to the in a written form. To whom? To the drawer, not to the drawee. Now, the liability of the drawer of a bill, there are the two circumstances which has been made. The bill I am using for the bill of exchange. So, the drawer of a bill of exchange is primarily liable until the bill has been accepted by the drawee, but after acceptance the acceptor becomes primarily liable. The liability of the drawer then becomes secondary to that of the acceptor. Thus, the liability of the drawer of a bill can be put in terms of the following propositions. The number one is, by drawing and issuing the bill, he engages that it shall be accepted and paid by the drawee according to its apparent tenor. Again I am repeating it, that by drawing and issuing the bill, he engages that it shall be accepted and paid by the drawee according to its apparent tenor. And the second proposition is that if it is the dishonored either by non-acceptance or by non-payment, he shall compensate the holder or every endorser who has been compelled to pay for the loss suffered by him, provided that a notice of dishonor has been given to or received by him. Now, come to the liability of a drawer of a check. Now, as you have already experienced, much concern that when we are talking about the check, the drawer means a customer and the drawee means the specified banker. So, the liability of drawer is always that if in case of the dishonor, he has to compensate it. He has to compensate it. So, the drawer of a check gives a guarantee to the holder that he shall be paid by the banker when it is duly presented for payment. If the check is dishonored, the drawer is liable to compensate the holder provided that he has received a notice of dishonor. There is, however, this difference between the liability of the drawer of a bill and that of a check, that the liability of the drawer of a check is primary and not secondary. I will come to that point. This is so because the holder of the bill can sue the acceptor, but the holder of a bill can sue the acceptor, but the holder of a check has no remedy against the banker. His remedy is only against the drawer. As per concern the bill of exchange, I have told you that the acceptor, that is the drawee, in case of the non-acceptance, he cannot be held liable, but if he has given his consent or he becomes the acceptor, he has to make that payment. If he is failing to make payment, then the both party can be held responsible for it, that the drawer as well as the drawee. But in case of check, as I have told you, that as the payee when he is presenting a check and if it is dishonored, the payee cannot ask anything, any questions to the banker. Why? The banker, as we know, that he is not responsible to answer it, because he is only simply he will talk about that why the check was dishonored. Then he will put the reason and he will return to the customers and he will not explain it, because this kind of the liability not lies towards the banker. The bankers only the return it. Now, what the next process? It is the duty of the payee that he has to inform whom? He has to inform the drawer of a check. So, there is a relationship between the drawer and the payee. There is no any kind of the relations between the drawee and the payee. So, here the payee can sue against whom? It can be sue only and only against the drawer, and the drawer has to compensate it. To make the drawer liable on the bill or check, it is essential that due notice of dishonor is given to or received by him, otherwise he will be discharged from the liability. No notice of dishonor is necessary in circumstances mentioned in section 98. There are the certain exemptions which he made. In remaining cases, that is responsibility lies towards whom? It is lies towards the payee, that the payee has to inform about the dishonor, and as soon as he informed or as soon as he noticed to the drawer is liable to make payment or drawer is liable to compensate it. Now, the fourth one is liability of drawee of a check. As you have already seen, when we have discussed about the relationship between the banker and customers, at the time I have told you that as a customers and the banker, the relationship when we are talking of the primary relationship, that is the creditor and debtor. Normally that the relationship is vice versa, but normally we understand that the customers is a creditor unless and until he is taking any sorts of, you can say, the advances or loans from the bank, his status is the creditor. As a creditor, it is a rights, and the bankers as a debtor, he has some sort of, you can say, the obligations, and that obligations has been under, you can say that he is under compulsion of section 31 of the negotiable instruments, that he has to honor every kind of, you can say, the order which has been issued from its concerned customers. So, as a customer, unless and until, as I have told you, that the amount is exceeding either from the arrangement or from the credit amount in the customer's account which is available. If it is not existing and if the check is presented in a proper manner, the proper way, then under section 31 of the negotiable instruments, a banker is liable to what? The banker is liable to honor that. So, the liability of a drawee of check as I have already said with you, it's Section 31 of the Negotiable Instruments Act 1881 provides that the drawee of a check having sufficient funds of the drawer in his hands properly applicable to the payment of such check must pay the check when duly required so to do, and in defaults of such payment must compensate the drawer for any loss or damage caused by such default. So, it is a compulsion, or you can say it mandates the banker under Section 31 of the Negotiable Instruments that he has to honor if it is properly, the demand has been properly made in a proper way, and if there is the sufficient fund in the hands of the customer's account, the banker has to honor. And if the banker is dishonoring negligently, in such cases the bankers has to compensate to its customers if any loss or damages occurred due to his act, due to dishonoring of the check without any valid reason, or you can say if the bank act negligently and if any loss or damages occurred, it's a duty lies towards the banker that he has to compensate its customers for the loss or damage which has taken place. Now, the liability of a maker of note and acceptor of bill, the note here means the promissory note and acceptor of a bill. So, Section 32 is talking about that. Section 32 of the Negotiable Instruments Act 1881 provides that in the absence of a contract to the contrary, the maker of a promissory note and the acceptor before maturity of a bill of exchange are bound to pay the amount thereof at maturity according to the apparent tenor of the note or acceptance respectively, and the acceptor of a bill of exchange at or after maturity is bound to pay the amount thereof to the holder on demand. In default of such payment as aforesaid, such maker or acceptor is bound to compensate the party to the note or bill for any loss or damage sustained by him and caused by such default. So, the liability towards the acceptor, that in case of the bill of exchange, and in case of the note, the persons who is responsible, the Section 32 conferred the responsibility towards the parties, and what is the responsibility that they will have to ensure, they will have to discharge their duties towards the pay and they will have to make payment. So, before I coming to that, I would like to share 2-3 things as I have told you. Let me tell you one very important aspect, that is the rights of parties. As far as the negotiable instruments, the right of a parties is only that he has the right to get the payment, failing which the only one rights which is available in the hands of the payee, that he can demand the payment from whom? The persons who is responsible. So, in all these circumstances when we are talking about, then we have seen that there are the various, you can say, the parties, they are liable and they are responsible in their own capacity, in what capacity or in what designations they are acting their role. So, in case of the liability of drawer, we have seen that the Section 30 which especially mention what, that the drawer of a bill of exchange or the check is in case of dishonor by the drawee or acceptor thereof compensate the holder. So, that is the right, but this right can, when that right can be exercised, that right can be exercised by the concerned person. The concerned persons mean the payee who is entitled to get payment from that persons. If it is dishonored or the payment has not been made, in that circumstances he can make responsible all the parties, or in other way we can say that he has a right to sue against all the persons, those who are involved there. The second things which I like to mention here, that the drawer of a bill of exchange. As my concern, the drawer of a bill of exchange, I have already mentioned with you, but I would like to mention again here that see the positions of a bill of exchange. The persons, he is making an order to the drawee. Who is the drawee? Drawee is the debtor, and there is a relationship between these two, that is the debtor and creditor. When we are talking about the debtor and creditor, as a creditor, the right lies towards what? It is the right of, you can say, the creditor, it is the rights of, you can say, the drawer, that he can make an order. As a rights he can exercise. Why? Because there is a pre-existing relationship between these two, between the drawer and drawee. As a drawer, he will have a right that he can make an order to its drawee, and as a drawee, it is his duty. The duty lies towards the drawee has to make payment, failing which he is responsible for it. They see, at the same time, they both are responsible. It does not mean that the drawer, in case of the bill of exchange, is not liable. For the payee, he can put both the parties in case of the non-payment, the drawer as well as drawee. But as far as concerned, there are the two propositions has been made. The first proposition was that the drawing and issuing a bill, he engages that it shall be accepted and paid by the drawee according to its apparent tenor. Apparent tenor, as you have already discussed under section 10, how it appears, means what amount is there, he is responsible to pay it. The second proposition is that if it is dishonored either by non-acceptance or by non-payment, non-acceptance or non-payment, he shall compensate the holder or every endorser who has been compelled to pay for the loss suffered by him, provided that a notice of dishonor has been given or received by him. So, that is the second proposition, also very important. As I have told you, in case of the bill of exchange, it is very important that the both party can be held responsible, liable, but the subject to what? The first and foremost thing is that what kind of the positions or you can say the circumstances lie there. You will have to check that if in case of the non-acceptance, the principal debtor is continuing their status, that is the drawer. As soon as the acceptance given by the drawee, the status is changed, but the drawer cannot escape himself from the liability. His liability as a surety. So, in case of the non-payment, who will pay? The persons who is the surety has given, he will pay that. As the third things which we have discussed, let me again in comparison with the rights, the liability of the drawer of a check. The drawer of a check, as I have told you, that what kind of the rights arises here? As far as the rights is arising as soon as he is handing over the check to the payee. Now, the payee is entitled to get the payment, but the directions have been made to whom? By the customer of a banker by issuing a check that he discharge his liability on behalf of the payee, and the payee is directed that you go there, you submit it before the drawee and the drawee will make payment. Now, the questions before us that suppose if the check is dishonored, in case of the dishonored, the right arises or there you will find that the payee is having some sort of the rights as soon as it is dishonored and it is received. But again I am telling here, I would like to mention one very important thing, that your rights you can exercise. Payee have a right to get compensation, payee has a right to get the amount from whom? From the drawer. It is very important, from the drawer. So, but the drawer liability, to establish the drawer liability, it is very important that the payee must issue a notice to the drawer for what? By informing that the check is dishonored. The check is dishonored. As I have told you, the banker cannot be held as far as concerned responsible in these circumstances. But I am not saying that it cannot be held liable. It can be held liable. When it can be held liable? Because the customer as a drawer, his liability is not over unless and until the payment is made by the banker. So, the rights, what kind of the rights? See, rights is available for both the drawer as well as the payee, but the rights can be claimed in the different party. The drawer can claim any kind of, you can say, if the loss occurred due to negligence of the drawee, the drawer is entitled to sue against the drawee. On the other hand, when we are talking about that the payee cannot sue the drawee, because there is no relationship between the drawee and the payee. The relationship is there between the payee and the drawer. So, the payee can claim compensation from whom? Compensation from the drawer, not from the drawee. Then the liability of the drawee of a check is, I have again and again I am telling you that when we are talking about the relationship between the banker and customers, forget about the everything what happened, but I find concerned that my understanding is that as a creditor and debtor relationship, it is the duty of a whom? It is a duty of a debtor to comply the order of the creditor, to comply the order of the creditor, but that relations must be continue in the same status. If it exceed, then the debtor is not liable to honor it. The same thing happens in case of the dishonor. There may be the various grounds which we will discuss in the next lecture, that when a check can be dishonored by the paying banker, that is a different issue. But I find concern as when the banker is discharging its duty as a paying banker, then under section 31 of the negotiable instruments, it is under compulsion, or the banker is under compulsion that he has to honor the check. So, honor the check here, it is only that it will dishonor. As I have told you, there are many technicalities, I am not going to that part, but the one thing which is very important, that the sufficiency of fund is very important. As I would like to mention here that the sufficiency, as far as concerned the bank, when he will determine that what do you mean by sufficiency, the sufficiency can be you can say determined by the two way. The one, by checking that how much amount, the credit amount is available in the customer's account. That is the one way in normal cases. But there are some special kind of accounts the banker who is providing at the time of opening such kind of accounts. I am talking about the current account. Mostly you will find that the current account, that is in the at the opening itself, that there are some sort of, you can say, the arrangements between the banker and customers. They entered into an agreement, and that agreement for what? For giving the overdrawn facilities. If there are some sort of, you can say, the overdrawn facilities are there, then the banker has to see that the banker has to go to determine the sufficiency of fund by going through that arrangement. If the arrangement is exceeding, then the bankers can say that there is insufficiency of fund. So, there are the two circumstances as I mentioned, that to determine that there is a sufficiency of fund. So, in that circumstances, in a conclusion I can say that the various liabilities which arises and the rights which is available to the parties, the rights can be exercised subject to, every time we find that in all the cases it is the duty lies towards the we can say that the pay, that he has to inform, he has to notice about the dishonor. And on the other hand, that the responsibility lies towards every party who is responsible to pay, or who is responsible to make payment to the pay, that has to be ensure that the payment should be made. Otherwise, that the liability lies, and the payee have a right that he can sue against them. With this, we will discuss some other things as far as the dishonor check in the next lecture. Thank you very much.